G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law Podcast. This video has been recorded on the 18th of November 2025, and I mention that date for a reason, because today's topic is an interesting case that is happening at this moment in the Western Australian Supreme Court. Yesterday, the case was heard in the Supreme Court, and I expect that judgment will be delivered in 6 weeks. So we'll see whether this video gets published in that 6 weeks. What's the case about? The WA Surrogacy Act discriminates against anyone who is not a single woman, a lesbian couple, or a heterosexual couple as to access to surrogacy. So the two big obvious groups, and they're not the only groups, are single men and gay couples. They can't access surrogacy. And I've given advice since 1988 in over 2,000 surrogacy journeys, and in broad terms, about half that group are gay couples. And a few single men, of course, some of whom identify as gay, some identify as single. But about half that group identify as gay couples. And of course, there are some who also may not identify as a heterosexual couple and therefore excluded, and we're talking about trans people, intersex people, non-binary. What's the case about? Well, the case was being argued yesterday that the Surrogacy Act in Western Australia is unlawful in restricting surrogacy by excluding those groups because it's in breach of the Commonwealth Sex Discrimination Act. The Sex Discrimination Act was amended in 2013 with a grace period for the states to bring their laws into line until 2016, in the case of Western Australia 2017. And the changes in 2013 were to ensure there was no discrimination towards LGBTQIA plus people. And why did that come about? Well, because Australia got pummeled at the United Nations hearing in Geneva, which said, why are you discriminating against those people? You should stop that discrimination. So changes were made to the Sex Discrimination Act, including the provisions of a service, that it is unlawful to discriminate on the basis of someone's sexuality, their intersex status, whether they're transgender, their relationship or marital status. And yet, that's what the Surrogacy Act in Western Australia says. We have seen in previous cases, 2 in Victoria and 1 in South Australia, that previous state laws have been held invalid when they have restricted access to IVF. The first was a case in South Australia involving I can't remember whether she was married and separated or whether she was divorced, but the point was she wasn't with her husband, and South Australian laws at the time said that she could not do IVF. And what did the full court of South Australia say in 1996? Well, the South Australian law was invalid under our constitution as a result, and she could have treatment. The second case was a few years later in Victoria, and is a well-known case involving a Dr. John McBain, who was most annoyed that his single woman patient was unable to access IVF in Victoria because Victorian law said she had to be in a heterosexual relationship. So he took the Victorian government to court, and the federal court said he was right, that the Sex Discrimination Act overrode the Victorian Infertility Treatment Act, and as a result she could get treatment. And the third case again was in Victoria in 2018, which said if you're a married woman you need your husband's consent to access treatment, and the federal court said no you don't, because to require that is discriminatory and in breach of the Sex Discrimination Act. So the reason this case is there at all is it would appear that the West Australian government is defending the case. Why it's defending the case, I don't know, because at the moment there is an ART, Assisted Reproductive Technology, and Surrogacy Bill before the WA Parliament, which I'll talk about in the next video. But if that's enacted, that is being implemented over a period of 18 months. And I'm told that the intended parents who are a gay couple challenging this law in WA don't want to wait 18 months, and nor should they. They want to get on their parenting journey now. So we'll see how the case goes, and when we get an outcome from the case, you'll see another video like this. Thanks for watching and listening. I'm Stephen Page from Page, Probe and Family and Fertility Lawyers. This is the Australian Family and Fertility Law Podcast.